right, good afternoon, and welcome to the Lawyer Assistance Program Oversight Committee meeting of the State Bar. As a reminder, this meeting is being recorded. Michelle, can you please take the roll?
Sure. So do you hear my phone ring? Hopefully that doesn't come through on your speaker. Heather Benton. James Hiding. Lisa Johnson.
Here.
Tracy Lesage.
Here.
Deirdre Nguyen.
Yeah.
Philip Spiegel. Elise Yenny. And Justin Dela Cruz.
Here.
So we have 4 out of 8.
Oh, we don't have a quorum.
So that phone call, I'm going to put myself on mute and turn off for a minute. That phone call was from Jim, so I'm going to see.
I actually just emailed him the link. He left me a message too, so hopefully he's gonna get it.
Great. Well, then maybe I don't need to call right back. Let's see.
Oh, Dr. Yenny just joined.
Hi, something is wrong with my background. It's just not working like at all. I'm not sure if I can get that
I
taken
see you're
off.
transparent.
You are transparent. That is odd.
I
Well, it's
promise
great
I'm
for
not a
government,
vampire.
right?
I think Matt has the country of the controls, Matt, to remove the background.
Yeah, let's see here. Now, unfortunately, usually when a meeting is already in progress, I don't think since it's based on a template I set up, but I'm going to try to see here.
I'll see if I can do it on my end. That's better?
Mm-hmm.
Okay.
Yes.
All right. Do you want me to try the roll again, Justin?
Sure.
Okay. Heather Benton, James Hiding, Lisa Johnson.
Here.
Tracy Lesage. Where did Tracy go? Are you still there? Oh, you're on mute, but I see you, Tracy. Deirdre Nguyen.
Yeah.
Philip Spiegel. Elise Yenny.
Here.
Justin Dela Cruz.
Here.
All right. So we have 5 out of 8 members, so we have a quorum now.
Great, thank you. Next on the agenda is call for public comment. State Bar staff will attempt to call members of the public first in the order that they signed up to provide public comment, and if no one signed up, then in the order they appear in the attendee pool.
For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon, and it should appear at the bottom center of your screen. If you wish to address the committee, please click the hand icon now, and the State Bar staff will call on you in the order that the hands are raised. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then the number 9. Again, doing so will alert staff that you would like to make a comment, and State Bar staff will call on you and open the microphone so that you can address the committee. Due to time restrictions, we cannot allow more than 3 minutes for each speaker. Please note that staff will have an on-screen countdown timer visible to all attendees during the duration of the public comment. The timer's 3-minute countdown will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. The on-screen timer will flash throughout the final 10 seconds.
Matt, can you please identify any members of the public who wish to speak?
Sure, let's see here. There are no members of the public who've indicated they would like to give public comment.
Okay, thank you. Next item is the chair's report. And the first topic of my report is that this is my last meeting. After 9 years of serving this committee, I think it's time for new, fresh ideas, and we're getting them. It's really been a pleasure and an honor of mine to serve on this committee. I was first a government gubernatorial appointee, and then got the honor of serving as your chair. And so it's been, for those who I've worked with for the last 9 years, really a great pleasure working with you and knowing you, and those who are going to continue to carry the torch. I wish you the best. So thanks everyone for making this a great committee to work on, and continue to press forward with this important work. Stepping up in my place will be Heather Benton as the next chair, and Jim Hiding as the next vice chair. We will also have a new attorney member who is also a psychologist, and that would be Dr. Catherine Young, whose term begins later this month and who will join us in the next meeting, where she'll be formally introduced. So next item is the staff report, and this item is being presented by Michelle Harmon and Ken Norse.
I actually, I will have plenty to say at later agenda items, so nothing right now. Ken, you want to take it?
Absolutely. Thanks so much. As mentioned, I'm Ken Norse. I'm a senior program analyst with the Lawyer Assistance Program, and I wanted to give you an overview of the outreach that we've been doing since the last meeting in July. In terms of both voluntary and mandatory lapse services overviews, we were able to present 2 times each at the OCTC ethics and CTAP schools that were held monthly. We were able to reach a total of 77 attendees through that outreach. In addition to that, we completed 4 sessions of LAP MCLEs, and those would be the prevention and detection program, as well as the wellness presentation. Through those methods, we reached 105 attendees, and I actually saved the most exciting and newest program that we've worked on for last, and that is our brand new ADHD support program called Refocus, ADHD Strategies for Success in Law, We literally just launched it yesterday, so it's a brand new program to all of us. Just a brief overview, it's a 6-week support program that will be held on consecutive Wednesdays, starting at the end of this month on September 25th. It'll be held from 12 noon to 1 p.m. Any California attorney that could be active, inactive, and disbarred, in addition to bar applicants and law students, are qualified to attend. I'm happy to say that it'll be led by Lisa Spenlove, who's an MFT and a very experienced lawyer assistance program group leader and mental health professional. In fact, my understanding is she's been with the program for 19 years. This program will target strategies for handling executive functioning and also focused on the reduction of stigma associated with ADHD. Our sessions, each one is thematic. The very first one is motivational regulation, followed by working memory, emotional regulation, planning and problem solving, inhibition and impulse control, and the final one will be self-awareness on October 30th. Although registrations have only been open for 24 hours, there's been a tremendous response from our legal community, and we already have a total of 972 registrations as of noon. We listened to many different groups and have solicited input on our programming, and I can say that we did hear a need for this kind of programming for many different directions. In structuring this program, we've taken inspiration from the 3 other state bars that already have this kind of programming, and that would be DC, New York, and Minnesota. And I cannot wait to launch this pilot and then follow up with an even better program next iteration. That ends my update.
Thank you, Ken. Wow, that's amazing to hear about the tremendous response and engagement on that program, and looking forward to seeing that program flourish. Are any questions or comments for Ken? Seeing, hearing none. The next on the agenda is item 3.1, approval of the May 31st, 2024 open session minutes. Are there any corrections or modifications to the open session minutes? Seeing and hearing none, may I have a motion and a second?
I'll move to approve the minutes.
May I have a second?
I'll second.
So I have Tracy Lesage moves and Lisa Johnson seconds. Michelle, please call the roll.
Heather Benson, James Heiting, Lisa Johnson.
Here.
Tracy Lesage.
Approve.
Deirdre Wynn.
Approve.
Philip Spiegel. Elise Yenny.
Approve.
And Justin Delacruz.
Yes.
Okay, so your motion carries unanimously.
Great, thank you. The next item on the agenda is consent. There are no consent items, so I'll move to the business portion of the agenda. The next agenda item is 5.1, discussion of the 2023 Lawyer Assistance Program fact sheet. Copy of the 2023 Lawyer Assistance Program fact sheet is attached to the agenda. This item will be presented by Michelle Harmon and Catherine Ongiri.
All right, so I would like to give you a little history of where this fact sheet came from. Hopefully you're all able to access it online. If you went to the agenda for the meeting, you might notice that there's a different agenda management system that went into place, I believe, between the last, it wasn't for the last meeting, it was between the last meeting and this one, or maybe the last one was the first, but you will see that there's a place to click on the attachments. If you look at each agenda item, you can either click on the name of the agenda item that has attachments, and there should be a little paperclip there indicating there's attachments, or the 3 dots on the right will get you to a place where you can download the attachments also. So you may also remember that this year, starting January 1st, our statute was amended to not require an annual report to the legislature. And in previous years, our annual reports They varied, but one of the things that they had in common that was very useful was some information about our statistics that we could use throughout the year then when people had questions about our population and about our numbers, who we serve. And so this year it's been difficult because we haven't had any new numbers for 2023. So we decided to create a fact sheet. So this is less formal. This is not going to the legislature, but this will be our document that we could use each year. You know, we're nearing the end already of 2024. The plan is to not have this at the end of the year. Now that we've got this concept going, the plan will be to create this fact sheet for our first meeting of the year and have it ready to present to you when we usually meet, like around March sometime. So then March we'll get the 2024 numbers. So you have this here. I'm not going to read through for you all of these statistics, but I'll tell you it's got some of the similar information as we had in the annual report regarding our intake numbers and closed cases and the reasons that people reported coming into lab at the time of their intake, like for example, whether it was a substance use problem or a mental health problem that brought them here, or both. I do want to highlight a couple of things for you, starting on page 4. One is the performance metrics. I don't think we had that in the old annual report, but that was something we reported to the board and will still be reporting to the Board of Trustees on an annual basis. And this is a response to a voluntary satisfaction survey that we send to all participants each quarter. So each quarter, when they have their quarterly paperwork that is required, they also have an opportunity to fill out a satisfaction survey. And because it is voluntary and because it is anonymous, it's the kind of thing that we think, it's maybe the complainers and people have something that they have a problem with who are the ones who are going to respond and take the time to write this out. But still our numbers are really good, and it's certainly at least meeting and in some quarters far surpassing our goal. In all of the categories, it asks several questions, but the one that the board has wanted us to report on is the information and services provided by LAP effectively and appropriately address my goals, and to have at least an 80% endorsement rate that people agree or strongly agree with that statement. And so as you can see, we're 85, 88, 94%. So that is, so that's good news. The next section underneath that is information about financial assistance. And that also is a little bit different, specific information. And we wanted to start including this because we know that this committee has been doing a lot of talking about our financial assistance, and it came up in the last meetings. It's going to come up in our other topics. And so you see here that there were 10 people. This was for 2023, right? So 2023, there were 10 people who applied for financial assistance. All of the people were approved. And then there's a table showing what they were approved for, because not everybody is approved for the same things. They are approved for 3, 6, or 12 months of only group fees or testing fees or group and testing fees. So the reason it has historically been very difficult to calculate how much money we have promised to loan is because the testing fees vary. We'll know exactly how much the group fees will be for this number of months, but testing fees will depend on the clinician who is their clinical monitoring analyst and how frequently that clinician determines it's appropriate for the testing in order to monitor, and what type of testing, because there are some tests that are more expensive than others. For example, if they're requested to do a blood test, that's going to be much more expensive than a urine or oral fluid test. So what I based this approximate maximum value on was if the person is doing the most expensive that we had lent. I look at and saw what we were lending out for people. So at the most expensive level of testing that we have loaned for people, if they were testing at in the average frequency, which for most of our participants, they start off twice a month, sometimes 3 times a month. So that's how I got to these approximate maximum values. So if it's 3 months of group fees, we know it was $750 for 2023, because that's the group fee didn't change. But it's when you add in the testing that changes. And then you can see when you go on to page 5 that the amount that was approved for loan is much more than what we actually paid out for the loan. So this is something we can look into a little bit more next year when we're knowing to look for this and can track the numbers differently, is why that is. It looks like, just from an unscientific glance at all the numbers, is that once the loan was approved, not everybody collected all of it. So they might have gotten approved for the loan, taken it for a couple months, and then withdrawn, or then just decided they're going to pay on their own. So people were not maximizing out all of the money that they were eligible to. Also, number is the amount that was paid out in 2023. So that also included some people who had still been approved in 2022, but were still participating. So, so that you'll see was 16,661 in 2023. So hopefully I will have information about 2024 beginning of next year. I think that was really what I wanted to highlight. We've got the demographic information, and then it goes into the support. So everything, I'm sorry, I didn't specify, but everything I was talking about was for the monitoring side of the program. So Kathy can talk about the support services side of the program.
Yes, thank you, Michelle. Can you hear me okay?
Yes.
Okay, great. So the support services section begins on page 8. And in 2023, we did fulfill 201 requests for transition assistance services. That's for our personal counseling, our career counseling. We did notice that the majority of people that were coming to us are between 30 and 39. They're female, they're white, and they identify as heterosexual. In terms of our outreach for the LAP program generally, we were able to conduct more than 65 presentations, and we did reach an audience of over 2,500 legal professionals. And as you can see, the demographics and the charts indicate the presentations that we've concluded, and so that's what's included there. And then we also have a bit of information about where we might want to go, or specific populations that we might want to reach out to in terms of our services. Are there any questions? Okay, and support services does plan to provide an update to the Oversight Committee in December about all the work that we've been doing this year. I know we've been talking to you about the different programs we've been piloting, and so we will provide updated figures around those numbers in December as well, at least up to that period. Thank you. Oh, Jim, you're on mute.
Hey, first of all, sorry for being late. I had problems entering the Zoom meeting with the computer. It was my issue, so I appreciate it. The second thing on Catherine, with your numbers, do you feel like this is lower or higher than your expectations, the numbers that you've achieved? First of all, we appreciate that, and congratulations on doing all those presentations. But secondly, I was just wondering how your assessment is as to the numbers and whether you expect increases or decreases in the future, and why.
So the utilization rate has been pretty consistent. Unfortunately, we're just not able to get more people to use our services for whatever reason it may be. If it's fear of the bar, or, coming to your regulator for help. But these numbers are pretty consistent with the last few years. Of course, we want to increase our utilization rates, and we are looking into ways that we can do that. So we are exploring some ways to increase that. So hopefully, ideally next year, we can increase the utilization for our transition assistance services. In terms of our outreach programs, we think that will stay pretty consistent, although we are considering putting up MCLEs on our learning management system around the prevention and detection of substance use and the wellness side. And those ones will be basically kind of on demand for any attorney who wants to watch them. So that may increase the visibility of those programs and of the lawyer assistance program. Thanks for the question, Jim.
Any other questions for Michelle or Kathy? Okay, thank you. Next on the agenda is item 5.2, update on July 2024 Board of Trustees meeting regarding proposed LAP rule changes. This item is being presented by Melanie Lawrence and Michelle Herman.
Hi there. So really just briefly, we wanted to let you know where we are with this item. You know that a lot of work went into making recommendations to amend a number of the LAP rules. So we did present the item at the July Board of Trustees meeting, and they did send the item out for public comment. The public comment period ends on September 27th. So if you or anyone you know want to make public comment, you can go to the website to do that. And the plan will be then that we will incorporate and consider the comments and bring the item back to the Board of Trustees in November for their meeting and ask for, presumably ask for adoption of the new rules. In addition, the other reason that we wanted to update you on this is you may remember that the item that we shared, I think we shared it with you, that went to the board in July included information about the fiscal impact that the change to the financial assistance program from a loan to a grant would have. Essentially, the actual change will have no impact, but the important information that was in there that we wanted to just highlight for you is that at least as of July 2024, the program was projected to have, by the end of this year, an 8% reserve. And, you know, the board policy on reserves is that programs maintain a 17% reserve. So obviously 8% is under that. There is a budget adjustment that the bar does every year, and it's coming in September. It will be on the Board of Trustees meeting for September. And so there will be material posted, I think, relatively soon for that. But I'm told that at this point, it actually looks like we'll probably be in a better position than was anticipated in July. And I think one of those reasons is because it was highlighted for us. We've really been mindful about, you know, the budget for the remainder of the year and curtailed some of the spending that was initially anticipated for the year. So it's more likely that will be in the range of 13% reserve, which is still under 17, but better than 8. But the reality for us and for you is that, you know, until we get to early 2025 and have closed the books on 2024, we won't really have a clear picture about where we have ended for the year. We are okay for 2024. But, you know, the fact is that our revenues have been flat for many, many years. And the costs of the program, and particularly labor costs, have increased. There will be some opportunities for savings in 2025, in particular, the lease of the building that's across the street that has some of our LAP team in it will end in, I think it's May of next year. So that'll be some cost savings. But we may be looking at, you know, needing to rethink what we're doing or how we're doing it, at least into 2026. So it's something else that we may be talking with you about next year, and we'll have more information. But for now, we just wanted you to know sort of that's where we're at for now. And, you know, we can revisit this again next year. Any questions? Okay. Thank you.
Thank you, Melanie. Next on the agenda is item 5.3, summary of recommendations of Board of Trustees or for Board of Trustees regarding the Alternative Discipline Program. This item will be presented by Bridget Graham and Melanie Lawrence. There are several documents attached to the agenda for this item, the primary one being the summary report titled Summary of Recommendations for Board of Trustees regarding Alternative Discipline Program.
Okay, great. So you all know that the Board of Trustees last year tasked this committee with looking at the rules related to the Alternative Discipline Program. And it's really as a result of work that came out of the Ad Hoc Commission on Discipline. and some of the concerns that were raised by some of the stakeholders. So you all broke up into working groups and went out and did a lot of work to think about, what we've been doing for a number of years, sort of looking at the data that we have and hearing from the stakeholders and being really thoughtful about some recommendations that could be made. So this document summarizes sort of, why we're here and the recommendations of the working group. Before we get into the meat and potatoes of those recommendations, I do want to highlight a couple of things that I think we have to be mindful of as we work through this document. At the conclusion of our discussion, you're going to be asked to vote on how you want to move the options forward. And right now they're sort of blank. So we have some opportunities to discuss and choose from a menu of options. But, as we were putting this document together and bringing sort of all of the work together, a couple of things really stood out that I think that we have to really think about. And one is that, I know that at least for the working groups that there was a lot of focus on, how can we increase participation in ADP? Because the fact of the matter is that the numbers for ADP participation have declined steadily over the years. And I actually noted in the item that for 2024, at least as of early August, there were only 4 people that started ADP. So the numbers are low. And so I know that the focus was and interest was on increasing the numbers, so which makes sense. However, what we also know and what's included in the document, and in particular on page 5 of the document, are the tables related to recidivism data that we have. And what we know is that for those people who participate in ADP, as compared to the way that other discipline matters are resolved. So by that, I mean, people who are just on regular probation, people who participate in what's called an agreement in lieu of discipline, which is not discipline. It's basically a contract with OCTC to complete some conditions at the end of which their matter will be closed and they won't be disciplined. Or reproval, which is discipline, but basically the lowest level of discipline that you could get out of state bar court. Those people who participate in ADP recidivate at a significantly higher rate than the folks who are resolved in other ways. And recidivism in this case is defined as cases that come into OCTC and to intake and then move into investigations. And so it is a pretty significant difference. And so when we think about increasing the numbers in ADP, we have to be mindful that the folks who are in ADP have a tendency to recidivate at higher rates. And so there's a bit of a disconnect there that we have to be mindful of as we're thinking about how the rules might change to increase participation and sort of what to do with that fact. And then the other thing is that, and one of the documents that's attached to the item is the concerns that were raised from stakeholders in 2007, and particularly the Supreme Court, related to, a number of items around the alternative discipline program, including that, people, the perception at least that people were not getting significant discipline. Maybe there were people in the program that shouldn't have been. And that's what brought about the additions of the ineligibility when, the misconduct includes moral turpitude, dishonesty, corruption, et cetera. Now, that was a long time ago, and, we're 15 years later. And so, maybe those concerns are not the same today. I don't know. But we have to keep them in our mind as we're thinking about, which of the options to advance. So with that in mind, we have 3 working groups, and the first one really related to the process and procedure. And I don't know I think Jim and Justin were both on that working group. I don't know if you want to talk a little bit about the recommendations that you are making, and with what I've said and the your review of the documents, how you might want to move this forward.
I'll defer to the chair until he says otherwise.
I was going to defer to you because you did the labor. You had the laboring work. I before I do that, I just say, you know, that the document lays out our recommendations. Jim and I met many times over the last several months, worked really hard on this. To put a lot of thought in conjunction and consultation with state bar staff. So I believe that, you know, what we presented here is kind of our modern approach and our thoughtful approach to where things should be.
All right, so I thank you, Justin. I will add that we really appreciate the help of Melanie Lawrence and Michelle Harmon and whoever else you used to put this together. We made probably more specific recommendations than were requested or required in many instances, with rule language that hopefully will find its way somewhere along the line into the actual rules. But this document, starting on page 7 and going through, where does it go? It goes through page 9 and ends up on right at the top of page 10. Does recite this in a summary fashion and an appropriate way the discussions that we had and the conclusions that we reached in regard to the rule changes. So you'll see where it says the process procedure working group recommendations. It has certain recommendations that are listed, and then it mentions modify to make referral, ensure consistent judicial assignment, etc., as topical items, and those contain the actual rule ideals and changes that we were recommending. And so Justin and I agree to all of the recommendations that are in here that are topical or bolded in your sheets that are there. So if there are any questions, we'd be happy to answer them or try to. We will be making the recommendations, and then when you get to the very end of the sheet here, the entire packet that we have, you'll have a resolution that is starting on page 14 and goes through page 15, and we'll be making the recommendation that the Oversight Committee adopt 1, 2, and 3 of the proposed changes. So that's all of those changes that are listed. Thank you. Thanks, Mel.
Thank you, Jim.
I did have one question. Very well done. I thought these were great suggestions and recommendations. But I know that one of the goals, at least it appeared to me, was that things would be done in a reasonable amount of time, like the stipulation and other things. I just wondered if there was anywhere in here that gave some guidance as to what a reasonable timeline or time would be.
We did include that in the presentation to staff, and included those a number of details that were time considered. But this summary, the ideals that are to be proposed, I think, to the Board of Trustees is rather more broad. And so not to concern itself with the exact details of how it should be affected.
Right.
So we left those out for this particular presentation.
Very good. All right, thank you.
There are a couple of sections where there are some time standards included. For example, in recommendation number 2, proposal on Rule 5.382B, which includes 90 days. Actually, that might be true now. And then on page 10, there's a discussion, sort of middle of the page, impose a 180-day deadline for eligibility determination. So, I mean, I think, you know, part of the challenge here, and sort of what Jim is alluding to, is that I think what's important is to conceptually have the recommendations, because I think when you're getting into the details, that likely the stakeholders are going to want some say in what that looks like. So it's important that, you know, and certainly we heard from stakeholders, you heard from stakeholders, that some of this takes too long, the feeling that some of it takes too long. Yeah. Right. So I think the 180 days, whether in the end it'll stay 180 days, you know, in the final version, I don't know, but certainly the Oversight Committee's perspective on that is reflected.
Great, thank you.
So, and I should say too, I mean, the plan would be whatever the recommendations are here, that we would be going to the board with them in November. And we're going to want to get some additional stakeholder input on the specifics of any recommendations. So the actual revision of the rules may not actually occur until sometime next year, and will be reflective, I'm sure, of the stakeholders' concerns. So. Okay, so the eligibility working group, Tracy and Lisa and Phil, I believe, were on this. Do you want to talk a little bit about this, and whoever is going to talk about it, maybe thinking about this issue related to moral turpitude and the considerations that I raised that sort of emerged as we put this together?
Who wants to take it? Because well, Phil, Lisa, me, who? Tracy?
Tracy put a lot of, we had phone conversations, but Tracy really put a lot of work into this, and I think really came up with some interesting points, and I think she did a great job.
Well, thanks. We couldn't really come to a consensus, and with Melanie and Michelle's guidance, we ended up putting forth options. You know, the moral turpitude definition is, we're not sure whether that is the sole reason or a major reason for declining participation or current participation in ADP. But we also are conscious of concerns, right, provided as far back as 2008, the Supreme Court regarding, attorneys causing harm to the public or to clients. So we try to be mindful of all of that and decided to put forth a couple of options. I will say in having, it's a lot of information to digest, and I really do appreciate the guidance that Melanie put in this document, because one thing of interest is that the stipulations, if we can maybe remedy the delay that it takes and the disagreements that occur in getting those completed and submitted, that may, offer us some guidance on which option we should choose. So it may be that we may want to focus on those changes that were put together by the first group, or the eligibility or the process and procedures group, and see if that does impact or change things before we go in and then, take out that definition. But I will say though, in all of our research and our meetings and everything that we've reviewed, there's no clear consensus on what it means. So I think that the goal was to open the program up widely to all attorneys, but not to attorneys who, whose conduct is so egregious that, they shouldn't be placed in the program. So I see why they wanted that definition, but unless we can come to some agreement as to what it actually means, it is causing some confusion. So I don't know if you if Phil or Lisa want to comment on that, but that's just sort of my general overview. You know, obviously our ultimate goal is to get attorneys healthy and back in the practice of law and have them keep their bar cards if they're able to, if they haven't, you know, if they're not going to be disbarred or have caused grave, egregious, you know, harm. That's my thoughts. Phil, Lisa?
Well, we really wrestled with this whole issue, and I'm just curious as to what other members of our oversight committee here could come up with for a good, concise definition of moral turpitude. Because as we looked into this, moral turpitude, the definition of it, I really didn't get it right. I really had no idea what it was. I thought it was something else entirely. So I'd be curious what other people can give us insight.
Well, I would just say I know you addressed the committee in particular, but to be helpful, moral turpitude is usually defined by case law. So that is one of the things that the committee looked at, is a number of different cases where that definition is discussed and interpreted. So, you know, usually it relates to dishonest conduct, stealing, fraud, that kind of stuff. But it is a bit amorphous, and I think it is something that people struggle with. And that is why one of the recommendations from the committee, if you wanted to address that issue of moral turpitude, which was something that came up in the ad hoc commission in particular, is to strike moral turpitude as grounds for ineligibility, but retain the words dishonesty and corruption, which are much more easily defined, and which still then retains the part of the rule, at least part of the rule that was added to respond to the concerns of the Supreme Court.
Okay. So this is Jim Hiding. I want to comment on this particular thing. We looked at this as part of our charge too, whether appropriate or not. But I think that we came to the conclusion that striking that altogether would probably be the most appropriate approach. There are a couple of reasons. One is the difficulty in defining the terms. Second is the difficulty in applying the terms between Respondents Council and OCTC. Some of the comments, if you read that Supreme Court report in 2008, were that there was a difficulty that in every case, or virtually in every case, the OCTC charges moral turpitude, and so how do you reach a stipulation when you have that charge pending out there, and the OCTC is moving forward with it, and the defense counsel are trying to reach a stipulation to get them into the LAP or into the ADP. So that, and I think that the issue is covered elsewhere, in that a person is ineligible if they are subject to, if they will be summarily disbarred. And so I think we come to the conclusion that if you're not going to be summarily disbarred, and we want to protect the public, the best way to protect the public is to get these people into a recovery program, to get these people into some kind of rehabilitation so that they don't reoffend. Now, I understand the recidivism issue, and I do want to point out on that recidivism issue that the agreements in lieu of discipline, if you look at that chart again, the agreements in lieu of discipline had the very lowest amount of recidivism, lower than anybody else on both charts. And so there's something we need to study there, something that we need to see as to why that's true, and why the LAP or the ADP is ineffective, or apparently ineffective, in preventing recidivism. So I agree with the comments and the observations, but I do want to point out that the agreements in lieu had the very lowest rate of recidivism. And so I think that if we cover this, if we've covered the issue with the summary disbarment as creating the lack of eligibility, then that covers everything that would be problematic in this portion 3, I think it is, of this rule. And so we can resolve that. We can get rid of the issue that it creates such problems with the stipulation and still maintain the ideal that summary disbarment makes you ineligible. All right, that's all. Thanks.
If I could just follow up for a moment on that, I do want to be clear when you're talking about summary disbarment that the only time that that's applicable is in a conviction proceeding. Right. So it's typically when there's a felony conviction involving moral turpitude. So there are a number of other instances where there is not a criminal conviction, but it's rather there are charges, ethical charges that may involve moral turpitude. So that these rules would apply in those situations.
My point was only that as long as you have the hope or expectation that this person will be a member of the state bar in the future, if they're not subject to summary disbarment, there's that expectation or hope that they will be a member of the state bar. The best way to protect the public is to get them rehabilitated. All right, that's all. Thanks.
That's a good point. So it essentially, I believe we're able to just put forth all 3 options unless the group doesn't like one of these and wants to discuss it. I would propose to just submit all 3 for consideration.
Well, as a member of the Oversight Committee, I defer to you. You studied it and you put it together, and we appreciate that and bow to your responsibility to do that. So at least that's how I feel.
Well, thank you. All right.
Okay. Anything else on the eligibility? We have one last working group. And I think Tracy, so. you're going to be it again because Heather's not with us. So this is on the collaborative courts working group.
This one isn't as complicated, but interesting. And Heather and I worked on this together, and we did a lot of research. She did a lot of research on other out-of-state programs that might contain sort of a diversion type, recovery court model. And she didn't find a lot, but she found some. And so we put some of that information in our report. But what we did consistently discover is that most stakeholders heard of what a collaborative court was, but had no concept of how it's formed or how it works or what the components were. So we thought it would be more helpful for us to put together a report explaining what a collaborative court is and how it might work in conjunction with ADP. In doing that, we met with Brian, I believe is his name, and he had actually prepared a report some time ago that he graciously allowed us to pull the excerpts from it, so we didn't have to reinvent the wheel and do the work ourselves, explaining how it could work and how it might work in conjunction with ADP. So I won't go into that because we attached his report as an exhibit or an attachment. But our proposal would be just that it's definitely a possibility. We think it's too early to make the call whether this could help, especially in light of the other rule changes that are going to happen or that may happen with eligibility and the process and procedures. Our proposal would be once it's decided by the board how they want to move forward with changes, that we just, continually review the statistics, especially on recidivism, participants who's applying, who's getting in, and the reasons for that. and see if things change, if they improve. One thing I did like, which I agree, I would wholeheartedly agree with, I think Melanie put it together, and I don't have them in front of me. I do, they're in my brain, which is full of information, but it also might be worthwhile to do some pilot type programs. I like the idea of looking into, you know, like a set clinician, you know, even if we don't go full collaborative court model now, a set clinician, because one thing that is common is that in collaborative courts, everybody knows each other. That's why it works. You have people with subject matter expertise, and they work together, and it's less adversarial. So we can maybe bring in some of those components that Melanie outlined at the end of this report. I don't think I printed them. It was long, so I only printed some of the pages. You know, I think this could help in the future, but I just think it's too early to know how we could use it and whether we should and to what extent. So our recommendation would just be to continue to study the statistics, you know, continue to look into perhaps adding some components that model a collaborative court and seeing if things improve and going from there. Other than that, I didn't have anything to add unless anybody had any questions or wanted to add anything. Let me add one more thing, because I did find on my notes, you know, I like the fact that like incentives for positive performance, that always, you know, tends to work. So you may be adding something like that. Melanie mentioned that. And maybe sanctions that are quicker, because you know, in collaborative courts earlier, you can sanction the behavior that's negative. You know, you get better results in the end. So you're quicker to identify, swiftly provide whatever the sanction might be, and get them back in the program and back on their feet. So maybe some of those things that we can look at, or the board can consider maybe adding those. But at this point, we just think it's too early to know whether we should go this route or not. So I don't know if anybody wanted to add anything or had any questions.
Tracy, I would just add that one of the other things that the item discusses related to collaborative courts is maybe a recommendation that we engage in some robust data collection and analysis related to ADP specifically, and the issue of recidivism, to determine, you know, who is trying to get into ADP, who gets in, who terminates maybe without completing, and why. And if there's a way to answer that question about why those specific individuals have a tendency to recidivate at a higher rate, might better inform sort of how we address that.
Absolutely. So great. We should definitely recommend that.
So what would happen with the other recommendations, the components of the model that are mentioned, and the that sort of thing?
I think that what might be best is, if you're interested in making a recommendation related to those, that there be further, something to the extent of further consideration and study, because I think what we would want to determine is how realistic and possible some of these are. I know that, you know, for example, when you're talking about consolidating cases with, for example, a few OCTC prosecutors or with a judge in the state bar court, it requires a commitment of resources that I don't know that stakeholders are prepared for. And there are other issues related to, for example, the incentives and the sanctions, that there would have to be some study of whether or not the state bar court currently has the authority to do that. My guess is perhaps not. And if not, how would the Supreme Court be willing to give that authority to the state bar court? So I think that there's probably some more work to be done in that area. But if you want the bar to pursue it, then certainly making a recommendation to that end would be helpful.
Thank you.
Thank you.
Okay, so should we get then to the resolution so we can be clear about how we're going to, you want to advance each of these? And Michelle, are you able to screen share? Because we're gonna have to do some additions on the fly here.
Can you see my screen?
Yeah, we can. So the first,
as you were all talking, I took some notes
okay.
for the first one. And so you'll see that there were these blanks in your item. You'll see the resolution and the blanks. So I started filling in the blanks based on what we were talking about, but please let me know if this doesn't capture it or if anyone wants to add or change.
So I think that, oh, you put all of the recommendations. Okay.
On number 2, though, it should probably say one of the options rather than all 3, because we're certainly not asking them to adopt all 3. Or
right.
Maybe we are adopting all 3 options. I don't know. But
what I heard was that the working group is suggesting that all 3 of the options go to the board.
Right.
Right. So that would be correct then.
Okay.
Okay. Can you scroll down?
So we're looking at, this is the wording that I added. And then the strike through for the inclusion in the report. Didn't make sense to me when I first read it, unless I need to relook at that.
I wonder if we should add in there about the data collection and study of ADP participants and recidivism rates.
I think that would be very important.
Okay.
Can we do that as rather all-inclusive because I'm really impressed with the idea that the agreements in lieu of discipline have the lowest recidivism.
Mm-hmm.
So that we're adding here. What are we adding here? The ADP recidivism rates?
Well, I think to Jim's point, though, to be more broad.
You could just say can study recidivism rates related to, or just recidivism rates related to participation in the various programs. How's that?
Okay. In various state board discipline programs. Are they programs?
No, I know. That's what I was trying to think of.
So
modalities?
They're really categories of individuals.
And what did you call them on that?
Yeah, maybe that. Discipline categories.
All right. So, and then these last 2 didn't have any blanks. This is about putting this item on the Board of Trustees agenda in November, and then delegating staff to make non-substantive edits. So shall I go through before we do a roll call vote? What we're voting on is first resolution: the Oversight Committee adopts all the recommendations advanced by the Process Procedures Working Group as described in this memo for inclusion in the report, and recommendations of the committee's study of the applicable rules involving referrals to the Alternative Discipline Program item to be placed on the November 2024 Board of Trustees agenda. And further resolved that the Oversight Committee adopts all 3 options advanced by the Eligibility Working Group for inclusion in the report, and recommendations of the committee's study of the applicable rules involving referrals to the Alternative Discipline Program item to be placed on the November 2024 Board of Trustees agenda. And It is further resolved that the Oversight Committee adopts the recommendations of the Collaborative Courts Working Group to further study the impact of the above recommendations on the program's utilization and recidivism rates before investing state bar resources into adopting a new collaborative court program, and further consider and study recidivism rates related to participation in various state bar discipline categories. And further resolved that the recommendations resulting from the committee's study of the applicable rules involving referrals to the alternative discipline program item be placed on the November 2024 Board of Trustees agenda. And further resolved that the Oversight Committee delegates to staff and the chair the ability to make non-substantive edits in the recommendations and to finalize them for presentation to the Board of Trustees.
All right. Hearing all that, do we have a motion and a second?
I would move that we adopt the resolutions as just presented and read by Michelle.
I second it.
Tracy moves and Deidre seconds. Michelle, please call the roll.
Heather Benson, James Hiding,
Yes.
Lisa Johnson, Lisa Johnson, I did not hear.
Yes.
Okay.
Yes.
Tracy Lesage,
Yes.
Deirdre Wynn,
Yes.
Philip Spiegel,
Yes.
Elise Yenny,
Yes.
Justin Delacruz.
Yes.
Right, so these motions pass unanimously.
Great work, everyone. That concludes today's agenda. There's no date set for the next meeting. Do folks want to look at their calendars, or does someone want to send out a doodle? How have we been doing this?
The group had lately been checking your calendars and agreeing on generally a Friday. At this time, although since Heather is not here and Heather will be the chair, I wonder if we want to come up with suggestions and then I can run it by her before finalizing. And since it is now September, if we wait for, we might be looking at a holiday meeting, we'll want to do this after the November board meeting so that you can hear about what happened at that meeting after we make these recommendations.
Sounds good.
So December, if anybody knows now that you're not going to be available a certain time, certain weeks in December, otherwise we're probably looking about Friday the 6th, Friday the 13th of December.
Just not between Christmas and New Year's, that's all.
Yeah, I would agree.
No, that's, okay. Well, then maybe the 20th, but probably we're looking at the 6th or the 13th of December.
It's okay with
Yeah,
me.
those both work for me too.
All right, so why don't I double check those two with Heather, and then we can send an email, or staff will send an email with the next date.
Will it be Zoom too?
Oh, that's a good question. We have budgeted for an in-person meeting this year and we haven't done it yet. So we could do that last meeting in person, which would likely be in Los Angeles.
Good for me, I vote for that. I like to exchange Christmas.
Yeah, it sounds good. I think I can make it to LA from Oceanside.
Mm-hmm. Everyone else just kind of nodding heads, pretty much. All right. So I guess, Justin, it's up to you to adjourn the final meeting that you're chairing.
Hey, thanks everyone again for all the camaraderie and hard work over the past 9 years, and so especially particularly this year, we did a lot of work. The most I think I've done outside of meetings since I've joined. So I really want to commend the whole committee on the hard work because we've been asked to do a lot and we've achieved a lot.
But before you say goodbye, really, we need to thank you a great deal for all of your input and how you conduct meetings. You conduct them in a very collaborative way, and you're a great gentleman, and we appreciate you a great deal. So thank you very much for everything that you put into this.
Absolutely.
Thank you.
Absolutely. Thank you so much, Justin. It's been great working with you and getting to know you. And you know, your calm demeanor, and you make the meetings feel effortless. So thank you very much.
Well, thank you, everyone. And yeah, that's definitely fake it till you make it. So
that's my motto.
we'll leave it at that. This meeting is adjourned. Thanks, everyone, and keep up the great work.
All right. Thank you.
Thank you.
Take care. Bye,
Right.
everybody.
Bye.
Bye.